Your Honor, Article 50, subsection 2B of the Constitution states that an accused in keeping with... We came here this morning, Your Honor. The first accused is here. We came here ready to take plea, now to be served with this, to look at this with his counsel prior to taking plea. It's really what the prosecution is trying to do is to actually just tell him, take the plea now on a document that you've not seen. It's just been given to your lawyer. It's very unfair, Your Honor. That should not happen, Your Honor. And therefore we're saying he's here, he's ready, but we can explain this to him, Your Honor. It's purely in keeping with the Constitution, Your Honor. That's all, Your Honor. Yes. The said documents were divided into two sections. And one was what they called a prosecution disclosure schedule. And the other one, Your Honor, was what they called a table of contents. Now, Your Honor, when we looked at these documents, they raised issues similar to the ones that we canvassed before you in case number 31 when we came for disclosure. But number 32. But the documentation in this particular case was in some cases totally different. So the issues arising that we raised or we saw after being supplied are issues that still call for us to have a session of disclosure before this court. Because, again, Your Honor, we have the similar issues of incomplete documents that were supplied.
Can I see what you have?
Yes, Your Honor.
DPP, give me what you supplied. Give me the inventory.
Sorry?
Today we were to deal with two issues and we shall deal with them.
Fair enough, Your Honor. Redacted statements, all those issues, same things. Reduction from D1 to
disclosure schedule that you are served with, can I have it? Defense?
They can supply a copy.
See whether it's in tandem with what you have.
Most obliged. So perhaps they can give the court a copy.
They've given me a copy.
Okay.
If you agree that it's the one, I will adopt it.
If we look at it, can we have a minute to just look at it? Just a minute, Your Honor.
You
as we cross-check
it online.
We just.
Kunda, where is yours?
I'm trying to access it.
We can also do the same as we see whether you've been given the same one. That's why we need to look at your copy, Your Honor.
Okay, just check. This one we must deal with it today.
Okay.
And finish.
So, the last B1.
On page 1, this is page number 9. Then B9.
B9.
Just wait. B17.
Here.
43, page 1711.
1711, that's okay.
B45. The bank account details.
And you
B48, page 1756.
1756, do you? Then B56.
B56.
That's it.
Page 44. We have page 44. Where we have to sign.
Just come back.
Come back to page. Come back to page 41. Page 41.
Yes. This J67.
Yes. Your Honor, we wish to confirm that what we have online, everything is good for the same way in terms of redacted statements, and also on the 14th and 15th of August 2020, prior to them amending the charge, which they want to amend this morning, they now need to indicate to this court whether or not they're supplying us new documents relating to the amended charge, because we don't have those documents. Yes. Then the other thing, Your Honor, the other thing, Your Honor, if you notice the document served upon you, the disclosure was meant to be count by count. And if you notice that what they're putting across in terms of the documentation is just generalizing and saying all counts, which of course is prejudicial to the first accused, and more so does not comply with the order that was made by this court. Yes. And more so, Your Honor, in light of the new amended charge sheet, if now the narrative is all counts, as per the document in front of you, how then will the new charge fit those documents unless they are to supply us other documents? Either way, there's a gap that the prosecution needs to deal with prior to the directions or prior to the taking of plea. Then, Your Honor, the other thing that is also quite apparent from what is in front of you is we will need directions on issues of redacted statements. Because, again, as you're aware, in the other matter before you, we were unable to agree with the prosecution. And here, you have documents marked D1 to D20. They're all redacted.
I will still take the same position.
So, yes.
Like I took last time.
Fair enough. And that's why I want to just raise it to the court that the court will have to give directions on that issue.
Yes, I've noted that.
Most.
You need directions
Yes.
on issues of redacted statements.
That's all, Your Honor. That's all, Your Honor.
Before they reply?
Currently in the documents that have been supplied to the court, disclosure was to be done count by count.
That one I have a problem.
Yes.
Justice Onyego in his ruling disagreed with me. Maybe they are taking advantage.
Fair enough, Your Honor.
Yeah. So argue, knowing that that is the position of the High Court.
Yes, Your Honor. So the list of exhibits you've been given, the inventory you've been given this morning by the prosecution states that they've disclosed on all counts. there's disclosure on all counts.
Yes?
Your Honor, and this, as the way this court has been informed this morning, is that there's a new count, in particular count 2, that has been introduced in the new amended charge sheet. And that, which is also very important, that the new particulars that have been changed in the previous charge sheet. Your Honor, therefore it's our position that on the matter of disclosure, there is no disclosure.
Yeah?
There is no disclosure on this new charge sheet. And we similarly request for time to look at it.
Fair enough. Deputy?
The substratum and the substance of the charges remain the same. We're not introducing any new issues different from what we had earlier filed. And Your Honor, applications of this nature, the defense, the issues the defense can raise with respect are issues to deal with the charge, whether the charge is defective or not. That one has not been done.
Now there was the other issue whether the new amendments the narrative to all counts, how will they fit in the new document? I think you've answered that.
I've answered that, Your Honor.
Now the other issue on all counts, eh?
Your Honor, it's difficult for me to confirm that because I haven't even seen the new charge sheet.
Yeah?
I haven't seen the new.
No, what I wanted is what the question Mr. Miller asked.
Addressed by the High Court. In revision number 8 of 2020 and in number 42 of 2019. The issues of... So, Your Honor, unless there's any other issue you want me to address, I believe in summary I've addressed all the issues.
There is no, we haven't shown any prejudice. The police taken that.
Your Honor, the substitution of this charge, there is no prejudice occasioned. Since we brought it at the earliest opportune time, we will not even commence the trial.
Now, up to this moment I'm satisfied
Yes.
that you have the documents. You have the documents. I will go on with the, unless there is an issue on disclosure. I want to go on, I finish with disclosure, then give directions on how the charge, on when the new charges will be read. Yeah, I don't want to waste time on that.
The way you think.
Any issue on disclosure?
It's okay. No.
It's all right.
No.
DPP, are you disclosing any new?
No.
No, we are not, Your Honor.
Yeah?
We are not, Your Honor.
Is it in record that the undertaker are not disclosing any other information?
But they have said they are not.
So we can expand that.
They have said they have given you all the documents. At this stage, that is enough for me to proceed.
It is okay.
Now, on the issue of redacted statements, Mr. Miller, I'm not changing my position
Yes, Your Honor.
because this case is being tried by this court.
So it's been heard by this court.
Yes, so I don't need to make a ruling on that. I will deal with it when that time comes.
That's fair enough.
Yeah, of course, I can see from what you presented,
Yes, Your Honor.
these are issues that can be dealt with at trial.
Leave your agreed.
If they give you an illegible document, we deal with it at trial. Because there are issues of admissibility.
Yes, that I'm feeling like
I think I'm very comfortable with that. So.
that's good. That's not good.
Fiona?
How many witnesses are you calling?
I'm calling Mark. No, you're not 20. You're not 20. You're not 20.
This is number 1.
Yes. You know we are calling 20 witnesses.
Thank you. You're 20.
Nothing else?
That's it, Fiona.
Not confirmation, as is alleging, that parties agreed that will be supplied with redacted statements 24 hours before the hearing. That document that you're looking at, which I also have a copy of here, does not have any submissions to that effect, Your Honor. So we still leave it to this court to give directions because there was no agreement.
What
as is
about
alleged.
item C?
Item C? Yes. Count by count. Is that the prosecution indicated they would rely on all documents for all the counts?
Next.
Then resolutions as agreed by defense counsels, prosecutors and investigators.
That's what I want to look at. Just give me a minute.
Yes, there you are, Your Honor. This particular charge sheet, I think the court has directed that you'll issue directions on that. So
Yes.
really,
Don't
need to
talk
go into
about
that.
the charge sheet.
I will not go into that. So I then will leave it to the court to give directions on the issue of the redacted statements. That's all. Because
That one I will give.
fair enough. I think beyond that, then
You must have gone through the documents supplied.
Yes.
The DPP indicates that they'll need, of course, they are calling 20 witnesses and they'll need 64 hours.
Yes. Let my colleague handle that one.
You know, on the redacted statements or documents,
Yeah?
on the issue of supply
Yeah.
or disclosure of the redacted statement, completely redacted or redacted in any other form, they have applied or suggested that the suppliers within 24 hours before the hearing. You know, this is an issue that we handled in the previous disclosures, and a direction by court was given on that.
What did the court say?
You know, being that first there shall be no adjournment after that particular disclosure of the redacted information.
Yeah.
But for purposes of the direction before this court, we do apply as follows. Number one, that 48 hours before the hearing will be supplied with that information. If the hearing is on a Monday, so that the 48 hours will fall within the preceding weekend to that Monday for hearing, then will be supplied the Friday preceding the Monday for hearing. Now, in calling for your discretion in favor of application,
Yes.
is that we need, you know, to prepare for hearing adequately and to compare that information with feedback from our clients. You know, that is a heavily interactive process, taking into consideration the voluminous documentation that will be comparable and linking the statements or the documents that were redacted information with the various documents or the relevance of the various documents or relation thereto.
Yeah. Yes.
So Your Honor, we propose that it be adequate information at the minimum, within which
48 hours.
yes, within which we can interact with all the voluminous documents, be ready for cross-examination and proceeding, as well as consult with our clients.
Are you offering plea bargain?
I think for purposes of, because you've
Because
asked...
I'll consider it in the pre-trial order.
Yes.
Any offer?
For now, we have no instructions.
Anything else?
On the issue of the witnesses,
Yes?
on the issue of the witnesses, we'll be requesting the prosecution to supply the defense with a schedule via the shared email.
I can hear your discussions, please. You're saying through a shared email?
Through the shared email. The same way they can supply the schedule of witnesses.
Yes.
Secondly, Your Honor, I seek the court's clarification on the point of the applications. That he said the court should not accept applications within the hearing and that they should come 7 days prior.
He said notice.
Notice.
And the position in this court is that I don't hear applications during trial. If you need to bring an application, you bring it on any other day other than a hearing date.
Right, Your Honor. Maybe we should leave it open.
Yes.
So that we deal with it during the hearing.
Yeah. If it's on admissibility, we deal with it there. Because no party will be allowed to introduce a document as the trial proceeds. I believe that's where we usually have problems. Anything else? Are you offering plea bargain?
Your Honor, I have the instructions. So we can just see.
I think what remains is on when to disclose the redacted statements. You are saying 24 hours, they are saying 36, can you agree? Charge sheet. Putting in mind this case has a hearing date. Yes. Defense, can you come back tomorrow? Just for plea?
Your Honor, tomorrow we are before your brother, Honorable and I, in Thika, on the other matter where we have to go and look at the premises.
Can you come back on Thursday? TPP, Monday 9 a.m.
9 a.m.
It's okay?
Yes. 3 plus here.
Days?
They came to 29 days.
No, how many days do we have
The
now?
one we have now.
Yes.
So we had Monday, the 14th. We had Tuesday also, Your Honor.
This matter will be heard on day-to-day basis. No adjournments will be allowed unless the issues causing the same are beyond the control of all parties. No application will be entertained during the hearing. Any such application to be made by the parties by giving a 7 days notice, and such application to be heard on any other day other than the day for hearing. Of course, this does not affect applications on admissibility of evidence. The redacted statements, let me just add something. You already have a common email.
Yes,
Yes.
So the redacted statements to be served on the defense 36 hours before the hearing through the common email. I hope you will not repeat serving the redacted statements. Yeah?
They may just do that, Your Honor.
No. I'll be here.
Your Honor, I think the order then says as much, because they're saying the redacted statements to be served within 36 hours.
So perhaps you need to say the redacted statements now unredacted.
Yes.
Just add an. Yes. The unredacted statements to be served on the defense 36 hours before the hearing through the common email. Now, the prosecution to supply a schedule of the chronology in which they will call their witnesses within 7 days of the hearing, and in case there is change, to issue such notice within 3 days of the 7 days. You issue 7 days. If there is change within the first 3 days, you follow it up with such change. Now, parties are encouraged to plea bargain, and in any case, all the court will need is such information to go on record that plea bargaining has been initiated. This will not be allowed to interfere with the trial. Court will only wait for the plea trial agreement in order to consider the same. In case there is need to use any electronic gadget, the parties to inform the court 7 days prior to that need. The prosecution's disclosure schedule acknowledged by the parties is adopted and marked Exhibit 1, this one, so that nobody runs away from it. Now, from the presentation by the prosecution and defense on the timelines the case will take, the trial may take approximately 144 hours. The case will be allocated 5 hours on a daily basis, translating to about 28 days. Hence, the matter will be allocated 28 days. That is before we allocated the fresh ones. Now, fresh plea on the substituted charge sheet to be taken on 14th September 2020 at 9 a.m. and hearing to proceed. Now we have further dates, further hearing dates 7 to 12 to 10th of December 2020, and other dates to be taken on the remaining 17 days on Monday, yeah?
Yes.
14th of September. That is that?
Yes, will you permit us to obtain the trial?
So I've said the pre-trial order to be availed to before I close the file. We adjourn.
I apologize for the delay. The first accused. Who is present for the first accused?
It appears the room for the first accused is empty.
The record indicates that Mr. Arum, is he present?
He is present, but like he has to be muted election.
Team, my name is Oundu for the second accused.
My lady, for the second accused person, my lady.
For the second accused, I have Mr. Lumumba, I have C. Odor, I have Mr. Oundo, and there was a fourth person.
My lady, for the second accused person, my name's Danstan Umari. I'm joining Professor Lumumba as the defense team.
I'm sorry, Council, the internet is pretty bad, so I'm not able to hear you properly. Mr. Lumumba, can you introduce your team, please, again?
I appear with Caroline Oduor, Jemima Aluda, and we are getting informed that there is an addition to our team. The more the merrier. So I hear Mr. Danstan Umari, I see them, and I hear Mr. Undo. So I think we are going to be 11 members of this team.
Okay. For the first,
my name is Arun.
so we have Mr. Arum for the first accused. Yes. Yes, Ms. Gishari, I believe this matter.
Yes, my lady. This matter was coming up for plea. We have uploaded the mental assessment as required by the court on Friday. But would you be in a position, my lady, to confirm if you have it in front of you?
I'm sorry, Ms. Gishari, it was coming for plea. What do you want me to confirm is present?
I wanted to confirm if you have copies of the mental assessment.
Yes, I do.
For the first and second accused.
Yes.
Then we are ready to take plea, my lady.
This phone is loud. As I told you, you enter with very. My lady, before the plea is taken, could I be allowed to inform the court?
Because the internet isn't very good, I will ask systematically, Mr. Arum, are you ready to take plea? Is the client ready to take plea?
Yes, my lady, you're very much ready to take
Mr. Lumumba?
Your Ladyship, I'm informed that the new colleagues who have come are put in an application, and I would want them to address you on that matter first, if you permit.
Pond. Where is the case number? Any case number?
Mr. Omari or Mr. Aundo, who has the application and what is the nature?
Mr. Omari, could you kindly address the court on the application you filed, please?
Thank you very much. My lady, the second accused person filed an application E22 of 2020.
Can anyone hear Mr. Omari?
My lady, I cannot hear him clearly.
My lady, is it clear to everybody? I'm a bit loud. Is it clear now, Mr.?
We are not able to hear you.
Is it clear? Hello, my lady, is it clear now? Is it clear now?
Yes, Mr. Omari, what is the nature of your application?
My lady, the second accused person filed an application E22 of 2020 seeking to defer the plea taking today. The same was filed in the morning. I'll be seeking directions from the court if that application is before you so that I can prosecute the application.
What I have heard from you, Mr. Omar, is that the second applicant has filed an application this morning in which he seeks to defer the plea taking. Mr. Omar.
Yes, my lady.
You were saying that the second accused has filed an application seeking to defer the plea.
Yes, my lady.
Yes, my lady.
I can highlight.
Has this application been served on Mr. Mary?
My lady, we have just filed it in the morning. That is why we were seeking that the plea taking be deferred. The application is put before you. Once you give directions, it is an application that if it is heard, the plea will not proceed. We have not gotten your directions, my lady, to enable us serve.
Pretty poor for some of you.
My name is Mawiti. I appear for this. I appear alongside Mr. Danson Omari for the second assistant.
Yes, Mr. Witness.
I want to submit an application LCCR E22 of 2020 has been filed.
Accused person defer the plea taking in this matter. That is what I understand from them. Mr. Lumumba.
Your Ladyship, I hear them. They have received instructions to which we, the three that I named, namely myself, Caroline Odur, and Jemima Aluda, are not privy to. But to the extent that it will impinge upon this, we'll go with the application, but its nature is of the kind that will obviate the need for plea being taken if it does succeed. But it appears from your record that what they have filed has not been availed to court, and in the circumstances, your Ladyship may then guide as will happen. Given that the first accused is ready to take the plea, our instructions this morning were to apply for bail. The circumstances notwithstanding, either before plea is taken or after plea is taken. Those are our instructions.
Your instructions are to do what, Mr. Lumumba? Again, you go first.
Our instructions were to come before you as he appeared before your brother Judge Wakiaga on Friday the 4th for plea to be taken and thereafter application for bail to be made. But in the intervening period, as a client is entitled to do, he has instructed another set of advocates, namely Mr. Omari, Mr. Witte, and Mr. Undo, to make an application for purposes of what they have described as deferring the taking of a plea. And I believe that the nature of the application is of much later that if you entertained it and granted their orders, then there would be no plea taken as regards the second accused. It is therefore fitting and proper that you entertain the application before the second accused is required to take a plea. Those are my humble submissions.
On our part, and I will really have no objection to the application made by my learned colleagues, Mr. Danso Romari and these other associates. I will be guided by the court's directions of the same. I'm guided by the reason that my client has been in custody for the last 14 days. And the continued detention at the police station is really prejudicial to his right, and he's ready to take a plea. I believe we can take a plea subject to your directions, and if any application is made on the behalf of the second respondent, the court will be in a position to deal with the same. Because even as per the orders of your brother, Mr. Okega, we were supplied with the
My lady, if I will respond, my lady, can I proceed? Can I proceed, my lady?
My lady, directions were given by your brother Judge, Justice Wakianga, that we are to proceed with plea taking today. We were told to ensure that mental assessment is on record, and that is what we've done. We have not received any instructions from the court or a court order stopping us from proceeding with the plea taking today, nor have we received any documentation from the court or from the advocates on this documentation. So what we are aware of is that we are supposed to proceed with plea taking today once the mental assessment is on record. So subject to your directions, my lady, we believe the best position as the judge before you, and it has two accused persons. We shouldn't encourage the taking of plea of one accused and not the other. So we request that plea taking be done today for both accused persons. Then if there's an application, we are either served or we are given interim orders, or we can proceed with that on that road. But today we should proceed with the plea taking, my lady.
Lady, can I respond?
There are no
My lady, can I be allowed to respond? My lady, are you getting Mr. Dunstan Omari? My lady,
Mr. Murray,
yes, my lady, a brief response.
try to be patient. The court will call on you the same way we do in open
Yes, my lady, I can respond briefly.
court. So now I'm calling on you. What do you want?
My lady, plea taking is such a critical issue. It changes somebody from being a suspect.
Mr. Murray.
Yes, my lady.
Mr. Murray.
Yes, my lady. Yes, my lady. Yes, my lady, are you getting me?
I do not know where you go, but I can't hear you.
Are you getting me? Could you place the file aside for 3 minutes? I change the gadgets I'm using. I'm at Milimani High Court. I'm just outside the High Court. Can ask the plea taking be deferred to enable him raise issues fundamental to his human rights. Yes, there was an order for a plea taking to be done today. That order was given on Friday. Saturday and Sunday were not working days. The accused filed his application. We have since confirmed that it has been placed before the court file. The nature of our application dramatically changes the status of the accused person. Right now he is a suspect. If he takes a plea without his voice being heard, Article 49 and Article 50 protects the accused person to be heard. Free counsels have pleaded that his rights be heard before the plea taking is taken. The state is adamant that the plea must be taken because it is the state that we are indicting. It is the state that is culpable in that application.
Mr. Murray.
Yes, my lady.
Mr. Murray.
Yes, my lady.
Because we have a big problem with sound, so try to be brief, get to the point so that you can make the directions in this matter. Don't try not to pontificate at this point. Just try and be brief and to the point so we get what you are saying.
My lady, our position is that the first accused person can take his plea. The second accused person's plea can be deferred. He's still in police custody. You direct, we serve and appear before you tomorrow for argument on our application, and therefore a decision on that is done before the plea is taken. The second accused person is comfortable being still in the arms of the state. That's all, my lady.
my lady.
S-U-G-E?
Yes. I appear with Mr. Oman.
You have just joined at the session, eh?
Yes. And my lady?
Mr. Suge?
Yes, I appear with Mr. Oman.
My lady, the matter.
Mr. Suge, please proceed. You're watching briefly someone for the victim. Yes.
Your name, present.
Yes, Mr. Suge, what did you want to say?
Mr. Manson.
Yes, my lady, together with the Suge, I'm leading on behalf of the family. We are watching brief. And on our part, we are objecting to the grant of the bail my lady.
What are you objecting to, Mr. Manza?
We are objecting to the grant of bail. Am I clear?
Mr. Manza, you are objecting to the grant of the bill, yes?
Yes, my lady. I'm opposed to the grant of any cash bail or any bond terms at the moment.
Anything else?
Where we are, I've been having difficulties trying to log in. I'm hoping that's the correct stage of the matter where we are. If it could be so, then I plead to continue with my submission.
Unfortunately, you have joined us rather late in the day, not on the record. So let me rule on what was coming before me that you have not been party to. My lady? Yes, Mr. Shehe? Plea taking until his application, seeking to defer the plea taking. The application is not yet on the court record at this stage. The first accused and the state are ready to proceed with the plea taking. I note that the accused are facing a joint charge of murder, and in my view to be prejudicial for the first accused to take. It will be prejudicial for the plea of the first accused to be taken in the absence of the second accused. Having not seen the application by the second accused, I'm not able to give any directions with regard thereto, save that it should be served on the state. I will defer the plea taking for 1 day until Wednesday, the 9th of September. The application by the second accused shall be served on the state. It shall be addressed and shall be canvassed tomorrow, the 8th of September 2020.
Much obliged, my lady. Accused person, Chris Philip Obure, has successfully deferred the plea taking to tomorrow, when his application will be heard, inter parties, and the judge will make a determination. The gist of the application that we filed is that Chris Obure, in the year 2017, was arrested and charged in criminal case number 15 of 2007, Republic versus Chris Philip Obure before the magistrate's court. The allegation was misuse of firearm. Remember, he's facing a charge of having his gun having been used to kill Omwenga. The trial proceeded and that case was dismissed. That case was dismissed on the 29th of May 2018. The gun was released to our client, the second accused person. This was a case where private business interests and other state agencies were witch hunting our client for the sole purpose of picking the gun and taking away the gun. That having succeeded, we were given an order to take to the Firearms Licensing Board. The order is dated the 29th of May 2018, where the gun was returned to the accused, to one Chris Obure. That gun has been in the safe custody of Chris Obure. The DPP has now approved charge sheet to charge Chris Obure. The CCTV footage that was aired by Citizen TV is very clear that the gun was stolen by his bodyguard. He was nowhere. He was at Kempinski when the alleged murder was done. The CCTV footage captures the bodyguard, the first accused person, taking the gun at 6 in the morning very early, returning it at the night, dusting the gun, wiping the gun, taking a bullet and replacing the bullet that had done the job. And therefore, the DPP and the DCI, within their battles that they are facing, they have decided to charge our client. We are objecting that under the law, Chris Obure should be a state witness. He should not be an accused person. The evidence that was there was not presented to the DPP. And that is why we are saying we want the plea taking to be deferred until the DPP himself is forwarded that tape, that recording, because the DCI never forwarded that evidence. Had he forwarded that evidence of the CCTV footage, then Chris could be a state witness. That is why we are objecting that the court has agreed with us that taking a plea drastically changes the status of a person. Chris, the second accused person, is a prominent businessman, a legitimate businessman who pays taxes, who is the branch head of the African region where his big company, the mother company, is registered in the US. It is business that has gone sour. The accused person, the deceased person, was never a friend. He's never even been to the accused person's, Chris's house. Neither was he there. Therefore, that is why we are shocking that this is proper raw abuse of state power. The criminal power, Article 157, that mandates the DPP to decide who to charge, should be exercised judiciously, should be exercised with caution in regard to public interest. And let us not have trumped charges being brought against the second accused person. We shall deliberate the matters tomorrow. The court has listened to us and given us a deferral for those issues to be dealt with. Yes, Justice Odunga has said that the DPP is the absolute authority to institute criminal charges. But that criminal decision, the decision to charge, must be exercised within Article 157 that guarantees the rights of an accused person. Let not anybody be brought to court because of the competitors in the business industry or the police force that is after arresting our client and charging our client. I will give the ruling for and the order for the police that in that criminal matter that is there. It is the same gun. Was the first accused person instructed to go and pick the gun and use it so that Chris Obure can face murder trial? Those are the many issues that we intend to raise before the judge tomorrow. Any questions?
So maybe why was it that necessary to file the application so that the second accused not to take the plea?
The issues we've raised need to be canvassed. The court supervised the application of Article 157. The decision to charge can be challenged by the High Court in the High Court, and the High Court can terminate the proceedings if there is evidence that the DPP has acted outside what the law provides, the powers he's given to him. That is the basis of our challenge. Thank you.